January 2023, wherein claimants saw the following reliefs against the defendant. 1. A declaration that the termination of claimant's appointment at the defendant bank by letter dated the 6th of May 2019 is unlawful, null and void, and of no effect. 2. An order of this court reinstating the claimant back to her employment at the defendant bank as if she never left. 3. An order of this court mandating the defendant to promote the claimant from senior manager to assistant general manager or any such higher position, which she shall have become entitled to by the date of judgment in this case. 4. An order of the court mandating the defendant to pay from May 6, 2019, all salaries, allowances, incentives, and benefits, as well as other entitlements and perks of which the claimant was deprived as a result of the unlawful termination of her employment. 5. An order of court directing that the salaries, allowances, incentives, and benefits, as well as other staff entitlements and perks to be paid to the claimant shall be commensurate and shall correspond with all mid-stages of her promotion and positions with effect from the earliest promotion date to the date of judgment, such that the amount the claimant shall be paid shall compare favorably with the incomes of other staff of the defendant bank at the same level who have been thus promoted by the defendant bank into similar higher positions. 6. An order of this honorable court restraining the defendant directly, indirectly, or through any other person, agent, or any means whatsoever, carrying out any form of victimization whatsoever against the claimant. 7. An order of the court mandating the defendant to pay the claimant the sum of 20 million naira as general damages for the unlawful termination of the claimant's employment by the defendant. 8. An order of the court mandating the defendant to pay the claimant the sum of 10 million naira as solicitor's fee for instituting this suit, which bill was foisted on her by the unlawful actions of the defendant. And finally, the cost of this suit as may be assessed by the court. And 10 is an omnibus prayer. The claimant case is that she was an employee of the defendant. She equally stated that sometime in 2018, the defendant bank commissioned the service of PricewaterhouseCoopers, PwC, to conduct an evaluation on the state of the loan portfolio of the bank, and she participated in the meeting held where a report of the evaluation was presented, wherein the executive director, corporate services, who was at the time the active managing director of the bank, directed that all staff responsible for the creation of loans, risk assets, who knew they were culpable in any way should voluntarily resign from the service of the bank within a period of 2 weeks, or they will be handcuffed and handed over to the security agencies. According to the claimant, she did not resign as she was not guilty of any lapses in the conduct of her duties, but that she was later summoned by the acting managing director, one Mr. Balabello, who directed her to resign without providing any specific reasons why he asked her to resign, insisting that it was conveying the board's directive, and in response to which she stated she would not resign, but rather requested for a justification. That she was not accused of any misconduct or fraud. She took several steps after the termination of her employment, which includes writing officers of the defendant to demand for her reinstatement, which steps prove abortive. Finally, the National Assembly intervened and urged the defendant to reinstate her, but it rebuffed their directive, hence this action. The defendant filed a statement of defense on the 22nd of February 2023, which was amended on the 5th of May 2023, wherein it averred that the defendant does not take instruction from the National Assembly on employment termination or reinstatement of person whose employment is deemed fit to terminate, noting that the defendant is a creation of law, by the dictates of which the National Assembly or its committees lack the power to order the reinstatement of former employees whose employment the defendant had terminated. It went on to state that having duly terminated the employment of claimant, the defendant never considered reinstating the claimant, as there is no legal or factual basis for such consideration, and that the defendant was always willing and able to pay the claimant her entitlements, but that the claimant made it impossible by refusing to execute all necessary documents that will enable the defendant to pay her applicable entitlements. The defendant further stated that having duly terminated the employment of claimant, the claimant ceased to be its employee since May 2019. In conclusion, the defendant praised praised that claimant action be dismissed in its entirety with substantial cost. On the 5th of June 23, claimant opened a case, testified for herself, adopted her sworn deposition, tendered documents admitted as Exhibit 8 to 813, and the defense equally called one Hisham Abdulkader as DW. He equally testified on behalf of the defendant. At the close of trial, both parties filed their respective final addresses. So I will now go straight to the decision of the court. Upon a careful perusal of the processes in this case, as well as the final written address, argument of parties in support of their diverse positions, I would like to recapture and adopt the issues framed by the parties, thus, whether the employment of claimant is clothed with statutory flavor, and 2, whether the claimant has proven a case to be entitled to the relief sought. First, I would like to decide on the issue of admissibility of Exhibit A14 raised by Adebayo Badmus Esquire, learned counsel for the defendant at paragraphs 4.1 to 4.5 of the final written address, which is a letter written by claimant to the managing director of the defendant, dated 6th of July 2023, to counsel. That document is not admissible for being caught up with the doctrine of lis pendens, in line with Section 83, subsection 3 of the Evidence Act, as amended, because it was made during the pendency of the suit on the 9th of October 2023, when Exhibit A14 was tendered through DW. Learned Defense Counsel was recorded to have objected to the admissibility of the document for being offensive to the said Section 83.3 of the Evidence Act. Worthy of note is the fact that the court has a duty to act only on admissible evidence. It is true that Exhibit A14 was produced during the pendency of the suit. However, it should be noted that Section 83.3 of the Evidence Act does not seek to render inadmissible every document that was made in anticipation or during the pendency of the suit. The determining factor is if the maker of such document is a person interested. A disqualifying interest is personal, not merely interest in an official capacity, where, however, the interest of the maker is purely official, or as a servant without a direct interest of a personal nature. There are decided cases that the document is not thereby excluded. These are B.B. Akbugu and Sons Limited versus OHMP, citation captured, Olomo and Akbe, High Grade Maritime Services and First Bank, citation provided. The said exhibit was prepared by the claimant herself, who is no doubt a party to this case, and was written during the pendency of this suit. As such, it is not admissible in law. There are plethora of judicial authorities in agreement that the court has a duty to admit only admissible evidence, but where it inadvertently admits inadmissible evidence, the court must at the stage of judgment treat same as if it has never been admitted, and same must be expunged from its record. See the case of Ikezuagu and Okonta, Agbola and the state, Suberu and state, Abubakar and another, and Joseph and another, citation captured. Consequent upon all stated supra, Exhibit A14 is thus expunged from the record of this court for being inadmissible in law. Now to issue 1. Let me address the contention of the defendant by paragraphs 6.1 to 6.24 of its final written address. That claimant raised the issue of statutory flavor for the first time in her reply on point of law, and thus should be discountenanced. Learned Defense Counsel submitted that it is not permissible for a party to raise a new cause of action, ground, or make fresh allegation of fact different from what has been set out in the writ or statement of claim. We refer the court to paragraph 10, subparagraph D of claimant's reply on point of law. First, I must say that paragraph 10D of the reply to the amended statement of defense, which counsel referred this court to, is not the first paragraph where claimant averred that her employment is with statutory flavor. In fact, the claimant had earlier in paragraph 3 of the same reply stated categorically that her employment is pursuant to Nezim Bank Act and enjoys statutory flavor, but counsel did not have an issue with this paragraph, but his contention is only with paragraph 10D thereof, which paragraph this court believed rests on paragraph 3, which comes earlier. Now, whether the character or color of this case is changed or whether claimant was raising a new issue by pleading that her employment is of statutory flavor ultimately depends on the facts averred. Just a minute, counsel. I'm on the gen, and I think there's something wrong with it, so let me continue with that. Now, whether the character or color of this case is changed, or whether claimant was raising a new issue by pleading that her employment is of statutory flavor ultimately depends on the facts averred in parties pleading. It is facts that will determine whether claimant has raised a new cause of action or allegation when she averred that her employment is with statutory flavor. Thus, this court will examine the facts in the pleadings in conjunction with the law in a bid to discover whether such is actually a new issue. The law cannot act in vacuum. It must be predicated on facts. After all, it is tried that facts are the forerunners and arrowheads of the law. Facts are the substrata or planes upon which the law perches, and ipso facto determine the nature of an issue or a case. Admittedly, it is not permissible to raise a new issue or cause of action not set out in the writ of summons or statement of fact or claim in the reply to the defense. See the cases of Olubodro and Lawal, Ishola and SGBN. In the case of Egisimba and Onuzurieke, citation captured, Toby GSC of blessed memory explained the function of a reply while relying on the decision, the case of Obot and Central Bank of Nigeria, wherein it was held as, I quote, "In general, it is not necessary for a plaintiff to file a reply if his only intention in doing so is to deny any allegations that the defendant may have made in the statement of defense. 2, a reply to merely join issues is not permissible. If no reply is filed, all material facts alleged in the statement of defense are put in issue. 3, the proper function of a reply is to raise in answer to the defense any matter which must be specifically pleaded, which makes the defense not maintainable, or which otherwise might take the defense by surprise, or which raise issues or facts not arising out of the defense. Also, a reply is the proper place for meeting the defense by confession and avoidance. 4, in order to allow a party to file a reply, the trial court must be satisfied that both the statement of claim and the statement of defense filed by the parties have not, when read together, sufficiently disclosed and fixed the real issues between the parties, and that further pleadings in the reply to be filed will achieve the purpose of bringing the parties to an issue, unquote. It is clear from the above that the proper function of a reply is to raise in answer to the defense any matter which must be specifically pleaded, which must sufficiently disclose and fix the real issues between the parties. However, the pertinent question at this stage is, can the averment of claimant that her employment is with statutory favor be a new issue that took the defendant by surprise? I've perused the pleadings of parties in this case, and I find that the defendant at paragraphs 4A of its amended statement of defense was the first to raise the issue of applicable laws, which govern the employment when it averred those, I quote, "The defendant, upon realizing that the claimant's service were no longer required, duly terminated the employment of the claimant in accordance with applicable laws by serving her letter dated 6 May 2019, terminating her appointment with the defendant," unquote. The defendant in its defense above averred that claimant's employment was terminated in accordance with applicable law, which presupposes that there are laws or statutes governing the employment which they alleged and that they complied with in terminating her employment. Claimant, while responding to the said paragraph 4 of the amended statement of defense, be it paragraph 3 of her reply, stated thus, I quote, "In response to paragraph 4 of the defendant's statement of defense, The claimant maintains her claim that her appointment was not lawfully terminated because the termination didn't follow the due process as stated in the staff conditions of service of a defendant applicable to all staff of the defendant, including the claimant employed pursuant to the Nezim Bank Act, thus enjoy statutory flavor, unquote. Thereafter, claimant by paragraph 10D of the reply thereof reiterated her position that employment is statutory flavor and cannot be terminated without due recourse to the provisions of the law already stated by the defendant in the statement of defense. In my respectful view, claimant's responses above could not have been a new issue that would take the defendant by surprise because the defendant was the one to raise in its defense that claimant's employment was terminated in accordance with applicable laws, and claimant in her bid to show that the defense of the defendant was not maintainable stated that due process of law was not followed in her employment, which is made pursuant to the Nezim Act and thus enjoys statutory flavor. As such, claimant merely answered the defense and specifically averred that her employment is one that enjoys statutory flavor, which of course must be specifically pleaded in order to meet the averment of the defendant headlong and to discredit it. The defendant, who having averred that claimant's employment was terminated in accordance with applicable laws, cannot be alleging that claimant was wrong when she responded that the procedures laid down were not followed as the Nezim Act governs her employment and thus statutory. Thus, the contention of learned defense counsel as to the issue being a new one is thus discountenanced. Besides, it is for this court to draw conclusions from the pleadings and evidence that the employment is one with statutory flavor or not. Be that as it may, I need to say that the question whether or not an employment enjoys statutory flavor is one of mixed law and fact, because the court will have to decide such within the factual milieu of a case, especially as it pertains to the conditions of service governing the employment and within the context of the law. I agree with the submission of learned defense counsel that the mere fact that an employer is a creation of statute does not operate to vest its employment with statutory flavor. Before an employment can be said to enjoy statutory flavor, two vital elements must coexist. That is, one, the employer must be a body set up by the Constitution or statute, and two, the statute or regulations made pursuant to the Constitution or principal statute or law must make provision regulating the employment of a staff of the category of the employee concerned, especially in matter of discipline. See the cases of Kwara State Judicial Service Commission and others versus Tolani, citation captured, the notorious case on this PHCN and Ufuelo, citation provided. In the case of OVVA and others versus Delta Steel Company Limited Supra, a case cited by learned defense counsel in his final written address, Ogumiju GSC at pages 24 to 26, paragraphs B to C, held entirely on employment with statutory flavor does, and I quote, an employment enjoys statutory flavor when the contract of service is governed by statute or where the conditions of service are contained in regulations derived from statutory provision. In the circumstance, they invest the employee with the legal status higher than the ordinary master-servant relationship. She cited in that case, Controller General of Custom and Reserve, unquote, it is a settled principle of law that where the words of a statute are plain and clear and unambiguous, the court should give them their literal meaning. See the cases of Carnation Registrars Limited and President of NICN and another citation captured, the case of Etisalat and Ihejieto, citation captured, Abegode and Ondo State House of Assembly, citation provided. The defendant is a creation of law, having been created by Section 1 of the Nigerian Export and Import Bank Act 1991, as amended by the Nigerian Export Promotion Council Amendment Decree number 64 and 65 of 92, and also in the 2004 laws of the Federation, hereafter referred to as Nezim Act. It is thus a creation of statute. The second element is that the statute or regulations made pursuant to the Constitution or principal statute or law must make provision regulating the employment of the staff of a category of the employee concerned, especially in matter of discipline. Now, Section 11, subsection 3 of NESIM Act provides thus, and I quote, "Without prejudice to the generality of subsection 1 of this section, the bank shall have power to A, to appoint such other staff as it may determine, B, to pay its staff such remuneration and allowances as it may from time to time determine, C, as regards any staff in whose case it decides so to do, to pay, or to pay to or in respect of such staff, such pensions and gratuities as are payable to persons of equivalent grade in the civil service of the Federation, and D, to give loans to its staff for purposes approved by the bank," unquote. The above provisions did impose some conditions on employment in the defendant, although specific conditions relating to discipline and all other matters are not therein. Parties in this case are not in dispute that it was pursuant to the above that the claimant was employed via Exhibit A and confirmed by Exhibit A1. It is effulgent from Exhibit A, particularly at paragraph 4 thereof, that the condition of appointment which is contained in the bank conditions of service in force from time to time are the conditions that will guide the employment relationship between parties. It is thus without doubt that the conditions of service of the defendant has been incorporated by reference to the employment relationship between parties. Section 9(1), paragraph G of NESIM Act provides that one of the powers of the board is, 1, to appoint officers and other employees of a bank to positions created by decision of a board and on such terms and conditions, including pensions, as shall be laid down by the board, unquote. It is therefore apparent from Section 9, subsection 1, paragraph G supra, that it is the board that has power to appoint officers to the defendant and on such terms and conditions, including pensions, as shall be laid down by the same board. It is the board is to make terms and conditions of service for employees of the First Bank pursuant to Section 9, subsection 1, paragraph G of the Act. Claimant in this case standard Exhibit A10, which is the conditions of service which according to her governs her employment. Let me pause at this stage to say that I do not lose sight of Learned Defense Counsel's argument, be it paragraph 6.25 of his written address, that the said conditions of service tendered before the court and relied upon by claimant does not have any indication whatsoever that it was made by the board of the bank as stipulated in the Act. I must say that it is an accepted principle of our law on the interpretation of any document that the document must be read as a whole and its parts interpreted in that light, and that an effort must be made to achieve harmony among its parts. See Anelo and others versus Maduaguna and another citation captured, Nigeria Army versus Aminu Kano citation provided, Agbare and Mimra citation provided. With this at the back of the mind of the court, I've gone through Exhibit A10 with the finding of a toned comb and mastery of an eagle's eyes. I find in the introductory part of the said Exhibit A10 does, and I quote, "This handbook has been prepared for the information and guidance of the staff of the bank. It is intended to assist staff members understand the general policy of the bank towards its staff, the terms and conditions of service under which they are engaged, and the regulations which are expected to govern their employment. The conditions of service stated herein represent a contract between the staff and the bank. It is expected that adherence to these terms and conditions will foster positive and harmonious relationship in the bank. It is essential, therefore, that staff acquaint themselves with the contents of this handbook so as to ensure smooth relationship with the bank. Staff should realize that failure to comply with the provisions of the handbook will not only hinder the progress of the bank, but will also affect their career. Guided by the provisions of this handbook, staff are expected to conduct themselves in a professional and ethical manner befitting of an export development bank. The provisions of this handbook came into effect on the 3rd of December 2018 and are subject to amendment by the board from time to time in response to changing operational environment and staff needs, unquote. Also, paragraph 13.10 of the said Exhibit A10 reads, and I quote, amendments of the conditions of service. A, the board may, from time to time, but not exceeding an interval of 2 years, amend the provisions of these conditions of service. Such amendments, when made, shall be notified to members of staff. B, where there is any doubt as to the current regulations in force, the Human Resources Department may be contacted for clarification, unquote. It is so clear as daybreak from the above captured clauses of the conditions of service that Exhibit A10 can only be amended by the board, although nothing in the whole of Exhibit A10 expressly stated who made the said Exhibit A10. It is pertinent for me to state categorically here that in the world of works, applicability of condition of service is not dependent on whether it is signed by the employer or employee. See the decision of this court in Roslyn Ekeng and International Energy Insurance PLC on reported suit number NICN/LA/122/2016, a judgment delivered on 18 June 2019. There's no doubt that the board referred to in Exhibit A10 as the one with the power to amend same is the same board created in NESIM Act, notwithstanding the fact that the appendix of Exhibit A10 at page 80 therefore refers to the board as the board of directors of NESIM. The composition of the board is contained in section 8.1 of NESIM Act, and they are: A, the deputy governor responsible for monetary and banking policy in the Central Bank of Nigeria as chairman. B, one other person to represent Central Bank of Nigeria. C, one person to represent the Federal Ministry of Finance. D, one person to represent the Federal Ministry of Commerce. E, two persons to represent private export interest. F, the managing director of the bank. G, two executive directors of the bank. Of note is the provision of the section 18.5 of the Interpretation Act, Laws of the Federation of Nigeria, 2004, hereafter referred to as the Interpretation Act, which provides those I quote. A reference in an enactment in relation to any matter, to any ministry or department or other unit of any government in Nigeria, described by a designation, which A, under the system of government in Nigeria or any part thereof. B, by reason of any change in the organization of any ministry or department or other unit as aforesaid, including the abolition or the amalgamation of any of them, or the creation of new ones, is no longer appropriate, shall be construed in relation to that matter as a reference to the ministry or department, or as the case may require, to any other unit of the government in Nigeria for the time being charged with responsibility for the matter, unquote. Paragraph 1.7 of Exhibit A10 provides for the composition of a said board. The board of directors referred to therein and the said composition is the same as those contained in section 8.1 of NESIM Act as captured above, except for variations as to the nomenclature of the ministries concerned by reason of change in responsibility, which is in line with section 18.5 of the Interpretation Act, especially for Ministry of Commerce, which is now Ministry of Industry, Trade and Investment. Therein in paragraph 1.7 of Exhibit A10, the chairman of the board is the deputy governor responsible for monetary and banking policy in the Central Bank of Nigeria, while the managing director of the bank, two executive directors of the bank, a representative of Central Bank, representative of Federal Ministry of Finance, a representative of Federal Ministry of Industries, Trade and Investment, and two persons representing private export interests, just as envisaged by Section 8 of NESIM Act. It is therefore clear that the board in the NESIM Act and the board or the board of directors in Exhibit A10 refers to one and the same thing, which means that the board referred to in Exhibit A10 is the same board referred to in Section 8 of NESIM Act. As reasoned supra, Section 9, subsection 1, paragraph G of NESIM Act gives the board the power to prescribe terms and conditions of employment of staff of the defendant. Thus, the board has power to make condition of service, and any conditions of service so made by the board becomes a subsidiary legislation or regulation, which gives the employment of its staff a statutory flavor. Section 12, subsection 1 of the Interpretation Act provides that where power is given to a person to make subsidiary instrument, the power shall include power to vary or amend the instrument, unquote. As such, the power to amend a subsidiary legislation is an integral part of the power to make same. It therefore means that the power given to the board under Section 9, subsection 1, paragraph G of NESIM Act to make or prescribe conditions of service shall include power to amend the condition of service so made. As reasoned earlier in this judgment, there is no express provisions in Exhibit A10 as to who is the maker of the said exhibit, but the power to amend same is expressly stated to be vested in the board, which, as resolved earlier, is the same board in NESIM Act. Section 167 of the Evidence Act provides that the court may presume the existence of any fact which it deems likely to have happened. Regard shall be had to the common cause of natural events, human conduct, and public and private business in their relationship to the fact of a particular case. By Section 167 of the Evidence Act, it is presumable, which accords with natural reason, that since the said Exhibit A10 can only be amended by the board, same must have been made by the board, especially as the power to amend is an integral part of the power to make a subsidiary legislation, as shown by the combined effect of Sections 9, subsection 1, paragraph G of NESIM Act, Section 12, subsection 1, paragraph B of the Interpretation Act. I must say that nothing put forward by the defendant has rebutted this presumption, which is in favor of the claimant's case that Exhibit A10 was made by the board, which has the statutory power donated by Section 9, subsection 1, paragraph G of the NESIM Act, as stated supra. This in effect means that Exhibit A10, which is the staff condition of service made by the board, qualifies as a subsidiary regulation to NESIM Act. I firmly believe, without any iota of doubt, that the claimant's employment, as well as all staff of the defendant, is one laced with statutory flavor.
As God pleases.
It is also pertinent for me at this stage to state that this court received a letter from learned counsel to the defendant on the dated 8th of February 2024, but was received on the 12th of February 2024 at about 1 p.m. Attached to the letter is a judgment delivered by my learned brother, Hastrop J, in the case of Mrs. Adigumbolanle Busola and NESIM Bank, suit number NICN/ABJ/399/2022, a judgment delivered on 30th of January 2024. According to counsel, one issue raised in this case respecting the nature of employment of the claimant, that is, whether or not it is one that enjoys statutory flavor, was also raised in that case, and that the court upheld their position that the employment of Mrs. Adigun was that of master servant. I've in-depthly combed through all the pages of the judgment, and I've read the conclusion of my learned brother on the status of the claimant in that case. First, it is pertinent for me to say that no two cases are the same. Secondly, it is germane for me to say here again that being a court of coordinate jurisdiction, this court is not bound by the decisions in Mrs. Adigun's case supra. It is in the light of this that I refuse to follow the decision in Adigun's case supra. If the court accedes to the position of the defendant that the conditions of service was not made by the board of defendant, then who made it? And does the supposed maker has the power to do so? The onus of proving that the condition of service as Exhibit A10 was not made by the board is on the defendant, who has said so. The defendant has obviously failed to canvass evidence to answer these questions to the satisfaction of the court, as the law is tried that he who has said must prove. The position of the law and facts stated by the claimant means that Exhibit A10 was made by the board of the defendant pursuant to Section 9, subsection 1, paragraph G of NESIM Act. This in view of all reasons earlier, which is entrenched in the provisions of the NESIM Act, the Interpretation Act, juxtaposed with the Evidence Act captured supra, it is without doubt that the two elements of employment with statutory flavor coexist in this present case. I cannot conclude issue Without addressing the argument of learned claimant counsel David Ashaulu, Esquire, in his final written address, that the public service rules also govern the employment relationship. It is a rudimentary position of our law that parties and the court are bound by the pleadings in the case. See the case of INEC and Advanced Congress Democrat and Order citation captured, Wema Bank PLC and Aristo Trading Engineering Company Limited and another citation provided. Thus, a party or its counsel or even the court cannot set out a case outside the one parties have made out in their pleadings. Claimant in the pleadings never pleaded the applicability of the public service rules to employment as such. Counsel cannot attempt to raise same, which has not been set out in the pleadings of claimant in his final address before the court. Counsel must also be reminded that address of counsel, no matter how beautifully written, cannot take the place of pleadings or evidence in proof of same. See the case of Ocean Deep Properties Limited and Access Bank PLC, citation captured, Hamidu and Kaduna Electricity Distribution PLC, and another citation provided, Uyemi and others, and Uwe and another citation equally captured. It is in view of the above that this court discountenances the submission of learned counsel as regards the applicability of public service rules to claimant's employment. In any case, I've earlier found that the two elements of employment with statutory flavor are present in the employment between claimant and the defendant. It is in view of all said above that this court finds without any equivocation that claimant's employment is one clothed with statutory flavor. Issue 1 is thus resolved in favor of the claimant against the defendant. It is a case of the claimant that the defendant terminated her employment without due process as stated in its condition of service and the act establishing same. It is a position of the claimant that her employment was terminated without any disciplinary action and also without any recommendation of a disciplinary committee as provided in the terms and conditions of the defendant. The defendant, on the other hand, argued that claimant's employment was terminated in accordance with the applicable laws. Now, Exhibit 10 as reason supra was made by the board of the defendant pursuant to its powers under Section 9(1)(g) of NESIMA and has been incorporated to claimant's employment and thus forms the terms and conditions of employment between parties, especially with regards to discipline and other matters. It is abecedarian law that parties are bound by the terms of their contract, and the duty of the court is to interpret the terms of the contract by giving the operative words in the document their simple, ordinary, and actual grammatical meaning. See the case of Assorted Foods and Integrated Beverages Limited and others with AMCOM and another citation captured. Ebunewu and Ejiewu citation provided, Union Bank of Nigeria PLC and Ozigi citation captured. It's equally tried that where the terms of contract of employment is one found in the statute or subsidiary regulation, as in this instance, the procedure provided, especially as regards termination, must be followed as any other manner of termination inconsistent with the relevant statute or subsidiary regulation is null and void and of no effect. See the case of Civil Service Commission, Imo State and others with Sozuguezo, citation captured, Oshiswanya and AfriBank Nigeria PLC, Bangbuya and Unilori, Olatunboso NISA Council, citation captured. Now, it is against this background that I will now consider the stipulation of the staff condition of service as contained in Exhibit 10 to ascertain if the same was complied with in the procedure leading to the termination of employment of claimants, since at peace of this matter is whether the said condition of service was complied with. The disciplinary procedure will now captivate the attention of the court, and it stipulates thus. I quote, I will just quote certain part of it. I've reduced the major part into the judgment. General policy. Disciplinary action may be taken against a staff member in accordance with the laid down procedure for misconduct as provided in this section. The following disciplinary measures may be invoked against any member of staff that violates the rules and regulations governing conduct in the bank, as well as their external relations with members of the public. Disciplinary actions, verbal, and there are different other ways, written query, and The acts of misconduct as stipulated by the conditions of service are all captured here. So I'll skip all that. In fact, in order to ensure compliance with the underlying principle of fair hearing in disciplinary procedures, the same staff condition of service stipulates in paragraph 9.3 at page 61 thereof thus. Disciplinary procedure, quote, fair hearing. In all cases, the relevant disciplinary committee shall allow a staff member against whom an allegation is made to defend himself or herself by giving him or her the facility to call his or her witnesses, if any, to examine or opposing them. So I will skip all that. I captured the appeal, the proceedings. On issues of termination, I've captured all that, so I will skip that. The above provision of Exhibit 10 captured above is clear. In the same vein, Section 11 of Exhibit 10 provides specifically for determination of appointment of employee of a defendant. It categorically stipulates in paragraph 11.3 at page 67 that, quote, termination, A, the appointment of a member of staff may be terminated as provided in paragraph 9.2.2e, unquote. Although paragraph 13.3 above uses the word quote and unquote may, ordinarily it means permissive. That is, the person who has a duty to carry out may choose among the available options. It has to be noted that there are no other alternatives provided apart from following the provisions of paragraph 9.2e in Exhibit 10. The principle to be drawn from decided cases on the construction of the word quote and unquote may appears to be quite clear, which is that the word may also acquire a mandatory meaning from due circumstances in which it is used. See the case of PDP and Sheriff and other citation captured. The case of Kurobo and Zog Motisons Limited citation provided. One of such is where there are no other alternatives provided, and which situation the use of the word is not merely facultative but mandatory. See the case of Olaoye and another, and Akande and other citation captured Adeshola and Abidoye citation provided. I think the use of the word quote and unquote may in paragraph 11.3 of Exhibit 10 places a duty on the defendant to follow the provision of paragraph 9.2e for termination of the employment of his employee, as there was no other alternatives provided therein. This is one of such situations where the word quote and unquote may connotes mandatory. From the provisions above, termination of employment of an employee of the defendant has to be in line with paragraph 9.2e, which provision deals with termination as a matter of discipline. It is clear from the above that termination of employment in the defendant is on disciplinary issue. Claimant's employment was undoubtedly terminated. There is nothing before this court to show that the above procedure as regards termination was complied with in the termination of claimant's employment. In fact, this is consistent with the evidence on record. I say so in view of the fact that claimant in her written statement on oath of 31st of January 2023 and the additional written statement on oath of 25th of May 2023 consistently maintained that procedure for termination of her employment as laid down were not followed, and that the defendant never saw the need to cross-examine claimant on this material point during her cross-examination on 5th of June 2023. The effect of failure to cross-examine a witness on a material point is in law a tacit acceptance of the truth of the evidence of that witness. See the case of Gambo and Issa and another citation captured, Cameroon Airlines and Ututuzi citation provided, Taiwan Adigboro citation captured. DW, while under cross-examination on the 9th of October 2023, equally admitted that the procedure for termination provided in Exhibit 10 above were not followed by the defendant in the termination of claimant's employment. I do not feign ignorance of the fact that claimant from her pleadings believes that the termination of her employment was as a matter of discipline, as she alleged that she was once asked to resign pursuant to a meeting held with the acting managing director, which move she resisted. The defendant, on the other hand, is maintaining a contrary position that claimant's employment was terminated as soon as it was discovered that her services was no longer required. It needs to be stated that it is effulgent from Exhibit A4, the letter of termination, that claimant's employment was terminated with immediate effect, though no reason was given for same. It is a matter of common sense that termination of a staff employment with immediate effect is not termination with notice. See the decisions of this court. Yunus Adewale Adefokwe and MTN Nigeria Communication Limited on reported suit number NICN/LA/492/2016, a judgment delivered on 15th May 2019. Case of Dorothy Adaize Awogu and TFG Real Estate Limited on reported suit number NICN/LA/262/2013, judgment delivered on 4th June 2018. It is also worthy of note, specifically within the banking sector, that termination of an employment with immediate effect suggests some wrongdoing on the part of the employee, which the employer must justify. See the case of Bello Ibrahim and EcoBank PLC is also under a reported suit of this court, NICN/ABJ/144/2018, judgment delivered on 17th of December 2019. Does this court believes the position of the claimant that her termination has some backdrops? The defendant, who would want this court to believe that claimant's employment was terminated because her services were no longer required, failed to justify why claimant's services were no longer required in an employment that is higher than that of an ordinary master servant. There is no scintilla of evidence placed before the court to justify the position of a defendant in their pleadings that claimant's employment was terminated because his services were no longer required with immediate effect, when it had already asked and requested that claimant should retire after a report of an audit report. It is so obvious that claimant's employment was terminated with reasons, though the defendant had failed to justify same. It needs to be pointed out that the Apex Court in the case of Lufiegba and others versus Abdul Rahim and other citation captured, the court per Adike GSC held that in an employment tainted with statutory flavor, as in this instance, the reason for termination of employment is very crucial to the case of both parties. The reason must be ascertainable and must be in accordance with documents and other instruments and laws governing the employment. Thus, an employment clothed with statutory flavor cannot be terminated abruptly with immediate effect without a valid reason, which must be ascertainable and justified by the employer, because such an employee is supposed to enjoy security of tenure. In any case, even if claimant's employment was terminated for services no longer required as asserted by the defendant, I must say that Exhibit A10 does not envisage such as the only termination of employment envisaged therein in termination of employment as a matter of discipline and no other. In fact, DW, who is currently the acting head of human resources, agrees while under cross-examination that if where an employee's service is no longer required, needed or required by Exhibit A10, the employment cannot be terminated. The only thing to do, according to him, is to declare the employee redundant and not to terminate the employment. There's nothing in Exhibit A10 to suggest that claimant's employment can be terminated for services no longer required, as I've stated earlier. The only termination envisaged by Exhibit A10 is termination pursuant to discipline upon committing a misconduct, in which case claimant must be given fair hearing, right from being given query, requiring her response to her appearance before the applicable disciplinary committee. I need to state here that claimant does not hold her employment at will, and her employment is not imbued with the status, and her employment is imbued with a status higher than that of an ordinary master servant employment as reason supra. Thus, the termination of employment must be in line with Exhibit A10 as any other mode of termination different from the one provided in Exhibit A10 connotes unlawful termination, which the court must set aside. In view of the above, I find that the termination of claimant's employment with immediate effect without complying with the procedure for termination as Exhibit 10 is unlawful, null, void, and of no effect. Thus, Relief 1 succeeds. It is the law of commonplace that the question of restoring an employee whose appointment has been terminated to his post normally applies to cases of employment that are clothed with statutory flavor. The claimant by her Relief 2 is seeking for reinstatement. The wisdom or rationale inherent in that principle is predicated upon the fact that once such termination has been declared unlawful, null and void as a result of failure of the defendant to comply with law and regulation made thereof, they are not allowed to act according to the whims and caprices of their human element. The employee will be treated as if the termination never happened and that the employee never left his or her employment. See the case of Kwara State Judicial Service Commission and others, and Tolani, Supra, Basi and AG Akwa Ibom State and others, citation captured, NEPA and Ango, citation provided. Having found that the termination of claimant's employment is unlawful, null and void, and thus such set aside, claimant is therefore entitled to a relief of reinstatement. Relief 2 thus succeeds.
God, please.
Claimant's claim by her Relief 3 is asking this court to mandate the defendant to promote her from senior manager to assistant general manager. It is the contention of the claimant that she ought to have been promoted by the defendant to the position of assistant general manager, but for the termination of appointment by the defendant. Claimant pleaded facts in support of this in paragraphs 32 to 36 of a statement of facts. The defendant, in response, by paragraph 7D and E of the amended statement of defense, averred that promotion within the defendant is not automatic, but based on merit, appraisal, availability of vacancy, discretion of the defendant, and other similar considerations. The pertinent question that should be asked is whether the defendant can be compelled to promote claimant. A perusal of Exhibit 10, which is the terms and conditions of employment between parties, provides us as regards promotion in the defendant, I quote, promotion A, paragraph 4.4. Promotion shall be based on staff demonstrated ability to assume higher responsibility during the performance review. Such ability shall be clearly documented in the performance appraisal report, justified during management committee performance review meeting. B, promotion shall be subject to available vacancies within the bank based strictly on the following criteria: consistent, satisfactory performance over the last 3 years, 3 preceding annual appraisal, demonstration of minimum skill, competencies, and proficiency required for the next job position. 3, absence of outstanding disciplinary sanctions, such as warning or suspension, possession of minimum professional and educational requirement for the next grade level, availability of vacancy, and so on. I'm skipping the rest, it's in the judgment. It is clear from the above provision that promotion in the defendant is not automatic and is subject to certain conditions and criteria, including availability of vacancies. Claimant in this case has not shown that she met any of the criteria for promotion provided above in Exhibit 10. Besides, the Apex Court in the case of Ngoye and FAN citation captured held that promotion from one level or position in an organization to another is not a right, but a privilege, which is earned. See also the case of Mamman and ICPC. It's a 2021 decision of the Court of Appeal. An employer cannot be compelled to promote his employee, no matter the good opinion the employee has of himself. This court is not the employer of the claimant, as such. Claimant cannot be asking this court in disguise to promote her from senior manager to assistant general manager. The claimant has not canvassed cogent, credible, and verifiable evidence to substantiate her claim for promotion. She has not shown this court that she has filled the prerequisites or conditions stipulated at Clause 4.4 of Exhibit 10 on the promotion highlighted above. It is therefore clear that claimant is seeking an ungrantable relief, except where she proves that the defendant failed to promote her after the fulfillment of all the indices leading to promotion in the defendant's employ, that she has failed to prove. It is in view of the above that I find that claimant's Relief 3 fails.
Okay.
Claimant by her relief 4 is seeking for the order of court mandating the defendant to pay all her salaries, allowances, incentives, and benefits, as well as all her entitlements. The law is firmly established that upon reinstatement, the reinstated officer is entitled to be paid all his arrears of salaries and emolument, including fringe benefits, up to the time of reinstatement and thereafter as and when due and payable. See the case of Ikeagu and Nigerian Army citation capture. In such situations, the employee does not need to prove any special circumstances to entitle him or her to the consequential relief or reinstatement and payment of salaries during the period in which the employment was unlawfully determined. See also the case of Mediora and FCSC citation capture. It is in the light of all status supra and having held hearing before, that the claimant is entitled to be reinstated back to the employment of the defendant. It goes without saying that the claimant is entitled to all her salaries, arrears, and allowances due to her, the same to be paid from the stoppage of a salary in May till date of delivery of judgment, and till they have to be paid till reinstatement and subsequently thereafter. I so find and hold. It is the claim of the claimant by her relief 5 that this court directs that her salaries, allowances, incentives, and benefits, as well as other staff entitlements and pegs, be paid and be commensurate with all the mean stages of her promotions and positions from the earlier promotion date till judgment is delivered. There's no doubt that this relief is dependent on relief 3 that is asking for promotion. It is right that where the principal relief fails, the ancillary or incidental relief will equally fail. See FAF1 and Bellevue Travel Limited citation captured. Zugbe and Kobe citation provided. I've held earlier in this judgment that promotion is not a right but a privilege which is earned. I've equally held that the defendant cannot be compelled to promote claimant in the instance. It is in view of this that claimant cannot be asking this court to direct that all her salaries, allowances, and incentives be paid as if he has been promoted. Accordingly, claimant relief 5 fails. Respecting relief 6, claimant is asking the court to restrain the defendants directly, indirectly, or through any other person or any means whatsoever from carrying out any form of victimization against her. It needs to be stated that reliefs sought are not part of pleadings. As such, relief sought must be based on substantial averments in the body of the pleadings. See the case of Trademark PLC and Pharmatech Industries P Limited. Please mute your phone. Polyphone, mute your phone. Claimant who has not averred in her pleadings that she's under imminent danger of being victimized or that there is likelihood of her being victimized cannot be asking the court to restrain the defendant or his agent from carrying out any form of victimization against her, as that will amount to taking the defendant by surprise, as there was no such averment in her pleadings. It is therefore clear that relief 6 cannot be granted. Relief 6 does fail. Who is Paul Efuna? Please mute your phone. Regarding relief 7, claimant is asking this court to mandate the defendants to pay her a general damages of 20 million naira for unlawful termination of her employment. It is the law that where a claimant seeks the relief of reinstatement, which relief is granted, the issue of measure of damages for wrongful termination or dismissal, retirement, as the case may be, or unlawful termination or dismissal becomes irrelevant because upon reinstatement, the party is entitled to be paid all his or her arrears of salaries, emolument, including fringe benefits, up to the point or time of reinstatement and thereafter as and when due and payable. See again the case of Ikeagu and the Nigerian Army and another supra. Having declared the acts of the defendant a nullity, reinstated the claimant in this case, and ordered that all her accrued benefits, salaries, allowances be paid till reinstated and thereafter, it is irrelevant to consider this relief because the grant of same will amount to double compensation. Consequently, relief 7 fails. I'll take Reliefs 8 and 9 together as they are subsumed under one head. As claimant by Relief 8 is claiming for 10 million naira as solicitor's fee, while Relief 9, she's asking for cost of this suit. I say they subsumed together in view of the fact that solicitor's fee is part of the cost incurred by a claimant in the prosecution of a case. The law is that a successful party in an action, unless he misconduct himself, is entitled to cost as of right. This position of the law is premised on the principle that cause follows or should follow events, and that a successful party in the litigation is entitled to be indemnified for all the reasonable expenses incurred in the prosecution of the matter up to judgment. See the case of Zenaka and COP Cross River State citation captured, Kappa and Alberto Nigeria PLC and NDIC citation provided. It is equally tried that the award or refusal of cause is at the discretion of the court, provided it is exercised judicially and judiciously. See case of Yakubu and Ministry of Housing and Environment, Bauchi State citation captured. On the authority of Mekwe and Emirates Airlines, citation provided. The course of action, including solicitor's fees, at the discretion of every court. And this court, by Order 55, Rules 1, 2, 3, 4, and 5, is empowered to grant costs at its discretion. I've gone through the whole of Exhibit A9, and I've juxtaposed same with the records of the court to consider the number of processes filed by claimant. Also, the number of appearances had on her behalf in this case, and the number of times claimant was present in court throughout this case. Having done the above, I find that claimant should be entitled to cost. It is in the light of this that I exercise my discretion by awarding cost in favor of claimant. I award the sum of 2 million naira as cost of action, which includes solicitor's fees. For the avoidance of doubt and the reasons earlier given, I declare an order as follows. 1. The termination of claimant's employment is unlawful, null, void, and of no effect, and same is hereby set aside. 2. Claimant is entitled to be reinstated to her employment and be paid all arrears of salaries and other entitlements from the date of the unlawful termination till she is reinstated and thereafter as a staff of the defendant. 3. She is entitled to the sum of 2 million naira as cost, including solicitor's fee. And 4. Reliefs 3, 5, 6, and 7 fail. Judgment is accordingly entered.
As the court pleases. My Lord, we are most grateful for the erudite judgment of this court. We pray that the Lord continue to increase my Lord in wisdom and understanding.
Lord, on the part of the defendant, we are equally grateful for the reasoning adduced in the judgment, and we equally pray for more grace and power for my Lordship to adjudicate on matters brought before this honorable court. Thank you very much, my Lord.
Thank you very much. God bless you all.
You're welcome.
I will rise. Copies of the judgment will be made available possibly tomorrow or latest by Friday, because I have to join my colleagues at NGI. There's an ongoing program going on now.
As the court pleases.
So you get copies. I only notice very minute typos that will be corrected and be forwarded to the court.
As the court pleases.
As the court pleases.